Hello, good afternoon, everyone. My name is Franca Ciambella, and I'm the Managing Director of Consilium Law Corporation. I'd like to welcome you to our session this afternoon on Singapore family law mediation. And before I go on and get right into the slides, can everyone hear me? Okay. I would like to, in the first slide, you'll see a list of all of our practice areas in family law, and you will see that we do the full gamut of legal requirements in the matrimonial law spectrum. Before I go on, I would like to introduce two people who have been very helpful in this afternoon, and the first one is Margaret Murata, who's our IT person and who is actually the host of this session this afternoon. And I'd also like to introduce Catherine Rose, who's a legal executive with us and who will be giving you a few logistical pieces of information before we get started. So Catherine, over to you.
Thank you, Franca. So hi everyone, thank you for joining us this afternoon. We've muted mics and videos for people joining to lessen the background noise and also to protect people's privacy. You may click on the chat icon at the bottom of your screen if you wish to type any questions into the chat box whilst we're doing the presentation, and I will put them to Franca at the end when we've finished. We will be recording this presentation in active speaker view to upload onto our website and to our Facebook page for your future reference. For those people also unable to make it this afternoon. So you will be able to see the slides and also to share them with anyone else who may be interested. If you do have any further questions that we have not managed to address, or if you wish to seek advice on your particular issue, you can email us and we can arrange for a free 30-minute phone conversation at your convenience. And our contact details can be found on both our Facebook page and our website. Okay, Franca, over to you.
Okay, thank you, Catherine. Okay, you should have on your screens our disclaimer page. And in addition to what Catherine has already said about the logistical part, I just want to highlight that this is not legal advice, and that if you have any legal questions, you can consult a lawyer. What we're trying to do here today is to talk about mediation in the field of family law, and take it as general information. And as Catherine said, we'll be happy to answer questions and speak further if you have any questions later on. Okay, right. You know, we often talk about alternative dispute resolution mechanisms, or ADR, and I thought it would be useful to just talk about the different possibilities that exist when you're trying to resolve a dispute. And this chart here looks at 4 methods of resolving disputes, of which 3 are what we consider alternatives, or ADR. So the first ADR one is mediation, which is what we're going to be discussing in greater detail today. And mediation in the spectrum of modes to resolve disputes is the one that's the most cooperative, the most conciliatory. So it's less litigious, it's less adversarial. And as you go through that spectrum, you know, the next one is conciliation. And conciliation is different from mediation in the sense that the conciliator takes a more active role in defining or in resolving the dispute than what a mediator does. And then, of course, we have arbitration, where it's like litigation, except it's private, and instead of having a judge, you have an arbitrator. But it's still, in the spectrum, it still gets more litigious because you have 2 parties represented by lawyers who are going to be pleading and arguing their cases in a confidential and private environment. And then, of course, you have litigation, which is the most litigious and most adversarial of the types of mechanisms for resolving disputes. So, as I said, the focus of our talk today is mediation, which is the method that we see the most often in the area of family law. So let me just try this. Okay, went twice. Sorry about that. Okay, mediation in family law. And this is a quote from the Chief Justice of Singapore, Chief Justice Menon, where he says mediation is a powerful tool in family proceedings where there are many areas of overlapping interests, in particular the welfare of the children, which can encourage parties to compromise. Parties are also more likely to adhere to settlements reached by consensus. And in fact, the Chief Justice has been a real champion for mediation in family law, and actually, generally to resolve disputes. Okay, and then he goes on to say again that the percentage of divorce cases under the simplified amicable process has increased dramatically over the years, and I'll leave you to read this. But also stating that while more and more divorces are being resolved through mediation and counseling, it's a good idea to do so because there's so much emotion involved in this space. And also, if the parties participate in resolving the issue through mediation, there's less acrimony, and they'll be able to, there's more of a likelihood that they'll be able to have an amicable relationship moving forward, which is so important in family law. So let's go on to this slide. So what exactly is mediation? So basically, mediation is a process where a third party who's neutral, the mediator, acts as a facilitator to assist parties in resolving disputes. So the role of the mediator is to help manage the process, help the parties, help guide the parties towards a resolution. Mediation is voluntary. It's non-binding for the proceedings. It's on a without prejudice basis until you reach the stage of an agreement. So the whole process is non-binding, it's without prejudice, until the point where you reach your amicable agreement and you sign the agreement. Then it becomes binding like a contract. In mediation, parties attend in person or these days virtually before a specially trained third-party intervener or the mediator. And most of the mediations that we have are in person, but I've done a number virtually via Skype or Zoom. And just this morning, I did a combination of I did a mediation that was a combination of telephone, Zoom, Skype, everything, you name it. This period where we're practicing social distancing and we're not able to work out of our workplaces doesn't mean mediation stop. We can still continue having them, but we can do them in a different virtual format. Okay, so I mentioned earlier why mediation in family disputes, and I talked a little bit about what the Chief Justice said. But why is mediation so good for family disputes? And part of it is the nature of family disputes, which are typically emotionally charged. And, when you do litigation in family disputes and there's a lot of emotion involved, it becomes a lot of tit for tat and people become angry, and then the litigation goes on and on and on. With mediation, in dealing with the disputes through mediation, you avoid all of that. And then the process of litigation can be lengthy, expensive, and stressful. In most mediations, we are done with the matter in just a matter of a week or so, because as I will explain later, we have a process of pre-mediation sessions, but the actual mediation itself is done within a day. Most of them are completed in a day, and in fact, I encourage them to be completed in a day so that the parties can move on with their lives. And also, if you linger beyond the day, chances are you'll start rehashing everything, and issues that you had agreed to the previous day are no longer going to be agreed to the following day. So all that to say that most mediations are completed in a day. The other reason why mediation is good for family disputes is because there are ongoing relationships between family members beyond the divorce. And litigation can be very acrimonious and go on for a long time. And sometimes with the litigation, relationships can be damaged beyond repair as a result. Before I go on, I just want to say something about the Singapore Convention on Mediation. And I just want to mention it before I go on because there's been a lot of talk about it. And as many of you know, the Singapore Convention on Mediation was signed in Singapore last August. And to date, I think there are 52 countries that have signed it. And basically what the convention says is if you have reached an amicable agreement through mediation in a signing country, then that mediation or that agreement is enforceable in another signing country. So it's actually the reciprocal enforcement of the amicable agreements that result from mediation. However, to date, the Singapore Convention doesn't apply to family law or to employment law, but it may be a matter of time before it does. So I just wanted to clarify that because we get that question very often. So as of today, the Singapore Convention on Mediation doesn't apply to family law, but perhaps that will change in the future. Okay. I talked earlier about ADR, alternative dispute resolution mechanisms available generally. And now I'm going to talk about the different types of ADR available for family disputes, and then I'll go on and focus more on mediation. Mediation could be of two main types. One is the court-directed mediation, and then the other one is mediation. Private mediation. And the one that we're going to focus on a little bit more is the private mediation, and that's the type of mediation that we do at Consilium Law Corporation, and it's the type of mediation that I'm most involved with, although I am part of the court scheme mediation, and I'm also an associate mediator at the Singapore Mediation Center. So there's the court-directed mediation, which is usually in two forms. The first one is called the Child Focus Resolution Center mediation, and it's compulsory if you have children under the age of 21. And typically that will be ordered by a judge before the first hearing occurs and relatively early in the proceedings. And then there's the second one that's called the Family Resolution Center mediation, which can also be ordered, but usually typically later on in the proceedings. And then we have the private mediation, which is through the Singapore Mediation Center, or private mediation in an office conducted by private mediators. And then there's a variation called the collaborative family practice. Okay, let me start with court mediation. There's compulsory court mediation and counseling in divorce cases involving children under 21 years old. And there's no mediation that's mandatory if there are no children involved. It's conducted by a judge, as I said earlier on, in the early stage of divorce proceedings. The focus is on children. It's free of charge, up to 3 sessions. And if there is an agreement, the judge mediator can record it as a court order, and it is enforceable. In the private mediation, I talked earlier about private mediation in a mediator's office or in a law office. I talked about collaborative family mediation or family practice, but there's also, in some cases, court-ordered private mediation. And this can occur when the gross value of all the assets is over $3 million and there are no contested children's issues. In other words, anything to do with the children has already been resolved and it's only to do with assets. So in this case, the court also has the discretion to direct parties to attend mediation at the Singapore Mediation Center or to go to private mediations if the parties can agree on a private mediator, and the court can also direct who's going to pay for that mediation. So a court-ordered private mediation is not free, but it's only if the assets are worth $3 million or more. I mentioned collaborative family practice, and actually this slide probably shouldn't be in here because it's not really mediation. And what it basically is, the collaborative family practice is when parties get together and they appoint lawyers, and the lawyers work together to negotiate the issues, but they share information. And the lawyers sort of play a mediation role, but they go back and forth. They encourage direct communication. They try to reduce acrimony, and they try to help the parties reach an agreement. One of the issues with CFP is if it fails, then the lawyers that have been helping the parties are not allowed to represent the clients any further, and especially if they go to court. Okay, now I said I would focus in on private mediation because that's something that I do quite a bit of. I've developed a sort of format that's a little bit different from other formats, but which has been very, very effective in the years that I've been practicing it. So in private mediation, as I said earlier, it's mediation that's done typically in a mediator's office, a lawyer's office, and it just involves the parties themselves. And I break it up into two stages, the pre-mediation stage and the mediation session itself. Again, private mediations, like other mediations, are voluntary. You can force parties to mediate. And if you do force parties to mediate, you know, it's less likely that they will abide by the resolution because it was forced on them. Okay, so it's a voluntary process. It can involve lawyers, or you can be unrepresented and have the ability to consult lawyers. As a mediator, when parties come without lawyers, which is fine, I make sure they understand what they're agreeing to. I make sure they're prepared, and I do that in the pre-mediation stage. And then, of course, if they need to, they're given time to consult with lawyers. And before they sign the settlement agreement, they're also given time to send the agreement to their lawyers to read before they sign, if they so wish. And again, parties appoint a trained mediator to act as an intermediary. Now, I said that I have a stage called the pre-mediation stage. And this is the stage where I typically meet each party alone, privately, without the other party, to talk about what's really important to them. This is where they tell me what their concerns and issues are. And this is where they tell me their priorities. And it's quite interesting what I find out here, because, you know, sometimes you go into a dispute thinking, okay, you know, it's going to be all about the children. And then, you know, the party comes and says, no, it's not really about the children. It's more about where we're going to live. And everybody has different priorities. Some people have, you know, the financial aspect is the hardest for them, and therefore it's the one that they want to tackle the most. You know, it could be the children, it could be the reasons for the divorce. So it's a number of things, but during this private pre-mediation session, that's where I talk about it and where I understand what's important to them, so then I can help guide them better. During the pre-mediation stage, I also come up with the list of agenda items based on what the parties have told me they want to discuss during the mediation. And of course, this list will include everything we need to discuss for court, but it'll include other things. For example, if somebody doesn't, you know, somebody has a problem with somebody's family members and wants to talk about the children being exposed to that family member, or a new boyfriend or new girlfriend, we can put all of that in the agenda items. And then we also set a time and a date for the mediation. And typically we reserve a whole day for the mediation, at least from 9 till 6, but some of my mediations have been known to go on till midnight. And I joke around and say, well, I'm going to lock the doors and won't let you out until it's all over. Usually for the mediation stage, as I said, it's a full day of mediation, and the parties attend before the mediator, before me. There's a process to it where it's hopefully constructive and it's an amicable approach to resolve the dispute. The mediator leads and guides parties through the process. And typically I tell them that you each will get a chance to speak, wait for your turn, and then we will go through the agenda one item at a time, so that we can discuss each issue thoroughly and hopefully come to a resolution. So some of the things we typically talk about is what is the way forward. And I try not to make any assumptions. Even if somebody comes and says, oh yeah, I want a divorce, you know, the way we approach it is we say, okay, what is the way forward? These are the options. Let's talk about what you want. So that the parties have the ability to talk about all the options open to them and then come to a conclusion. So we talk about the vanilla items that we need for a court process. For example, the way forward. Is it going to be a reconciliation, separation, divorce, or status quo? And you'd be surprised the number of people who come and they say, well, I want a divorce, and then during the mediation they say, okay, I'll do a separation for 6 months and then we'll see how it goes. So it can go differently from the way the parties originally started out. And then of course we talk about all the ancillary issues, like the children's issues, the division of property, maintenance, relocation, which of course, as many of you know, means the ability of one spouse to return to or to go to another country with the children. And then, as I said earlier, any other issues you want to discuss. And this is what I always tell people, that this is your mediation. We're here to help you, and we're going to discuss any items that you want to discuss. All right. In the mediation stage, I said earlier that everyone gets a chance to speak and to give their viewpoints on each of the issues. And of course, everything that is said is confidential. And as I said earlier, it's on a without prejudice basis, so it can't be held against you. And during the mediation, I'll sometimes do a private caucus, which means I'll separate the parties. And I'll do that typically if I see there's a lot of emotion or people are getting upset, or if I want to speak to the parties privately and I sort of want to understand where they're going and try to see if they can see the other person's point of view. Many reasons why we have a private caucus, but it's quite common in a mediation. The agreement at the end of the day, or at the end of the mediation, is drawn up by the mediator. And usually I don't do it myself. I'll have somebody in the room with me taking notes who will help draw up the agreement. And the agreement will contain everything that's been agreed to. If some issues have not been agreed to, then those issues will have to be resolved elsewhere. But most of the time we come to an agreement on all of the issues. And the parties have a chance to review the agreement. If they want to, they can have their lawyers on standby, and we can email the draft to their lawyers and they can discuss it with their lawyers before they execute it. We try to get all of that done in one day. So often they'll have to tell their lawyers to be on standby for an hour to read the agreement if that's what they want. And the agreement is legally binding and enforceable as a contract. I know people have a lot of questions on this, but you are signing a contract that is supposed to be enforceable. Now, as a contract, if there is a breach of the contract, then you are entitled to damages. In order for you to get an order, however, to force the other person to do something that's in the agreement, you would have to make an application in court. But most of the time, if a person has voluntarily come to mediation, the chances are very high that they will abide by the agreement. Okay. Benefits of mediation. I'm a big believer in mediation. I have seen how it's really been helpful to people and for many ways. And so some of the ways I see it's helpful is it saves time and costs. The process can be completed in just a matter of days rather than going through the judicial system, which can take months. There's no waiting for the judgment. You get your result right away. And the legal costs are kept to a minimum as the cases are settled quickly and with less involvement of lawyers. It also gives the parties a sense of a greater autonomy. In other words, they've participated in the end result. They've helped come up with the answer. So because they've done it, their input has been considered. There's a higher rate of compliance. The parties feel they have more control over the outcome. They feel personally empowered, and all of this together makes it easier for them to comply with the agreement. More benefits. It's a flexible process. Firstly, it's a voluntary process. It's confidential on a without prejudice basis. There are some rules, but no formal rules like in court. And you have the freedom to speak. You can speak, you can say as much as you want, but it has to be at the appropriate time. In other words, we want to give everybody a chance to speak, and we also don't want you interrupting the other party. All matters can be discussed, and not just the ones that the court is interested in knowing about. So there's a lot of flexibility, and as I said, I always tell parties, this is your mediation. You need to tell me what you want to discuss, and we'll do it. And there's also flexibility in terms of taking breaks, in terms of, if somebody is tired and says, look, I need to go downstairs and buy a pastry or do something, we can also respect that. It's less stressful because it's a more informal setting. There's less hostility, it's conducive to having people talk and really get things off their chest. Okay, well, I've come to the end of the formal part of the presentation, and you will have access to these slides and to this session because we are recording it. And as Catherine mentioned earlier, if you have any questions, please type them and send them in to her. And in the meantime, I understand, Catherine, we already have received some questions?
Yeah, we do. We have a lot of questions.
Okay, let's see.
I realize some of the questions you will have addressed already, but sometimes in the course of a presentation, it's difficult to take in all the information. So some of the questions that we often get. So number one, is mediation always offered by the courts before going to trial if in litigation? I mean, do we have to attempt it first?
Okay. If there are children involved, the answer is yes. If the court, in addition, if the court orders you to go to mediation, you do have to attempt it. And some of those are very short mediations because the parties arrive and one party will say, I don't want, I'm not agreeing to anything, and makes it very difficult. So the mediation ends quite quickly. So yes, in family law, yes, there are instances where mediation is mandatory. But as I said, in order for a mediation to, be the most effective, it really has to be voluntary.
So on that note, so someone said, oh, my husband and I can never seem to have a reasonable discussion on anything. So how is mediation going to help us? They're looking already at it with a negative attitude. So what if my partner is completely unreasonable? How can I convince him or her to try a mediation?
Right. Okay, we see this quite a bit, where one party is really sold on mediation and the other party is not so interested. And what we usually do there is we ask the party who's not convinced to come in and meet the mediator. That's the best way to do it. Go in and have a cup of coffee with the mediator, and the mediator can explain how it works. The whole nature of mediation and what they can expect. And often, when there is a reluctance to go to mediation, it's because they don't understand the process and they don't understand the benefits. And I would say 90% of the cases when, the doubtful party or the doubting party has come in to see me and we have a coffee and we talk about it, then they'll try it. They'll say, okay, I'm willing to come in and give it a try. The other thing to stress is that there's really no downside because it is on a without prejudice basis. And if the mediation fails, then it doesn't hurt you.
Right, I see. And I think still on that same topic, someone asked, if I suggest a mediation with a certain mediator and my partner thinks that somehow therefore that mediator is on my side, you know, how do you
get across that? Yeah. A good mediator, the minute a mediator is contacted by one party, their reflex has to be to contact the other party as soon as possible, so that there is no image or there's no perception that the mediator is on anybody's side. Right. The mediator should never be on anyone's side, because the mediator is neutral, doesn't have any decision-making powers, and is only there to guide you. The thing is, both parties have to feel comfortable with the mediator, and sometimes the optics are very, very important. So if somebody feels, oh, that mediator is close to my husband or close to my wife, they won't want to use that mediator, because the optics, even if it's not true, would suggest that the mediator is biased. So I can't stress enough, as a mediator, when somebody calls me, I always say, I need to contact your partner. Can you tell him or her to expect a call from me?
Okay, and I think another one similar, about parties who are obviously in a difficult situation, and that's why they need to sort these things out. But yeah, what if we find it difficult to be in the same room together during mediation? Not that it's maybe, well, if they're still living together now, it's possible via Zoom, I guess. But if it's the case in the future, you know, how do you deal with parties who are really...
I've even had parties who don't want to Zoom together. So, you know, there are instances where there is a lot of acrimony, and it's not ideal, but what I have done in the past is I've kept them separated. And the mediation has been, you know, basically me going back and forth and doing private caucuses with each of them, and then dealing with each issue one at a time that way. So I would pop into one office and talk to the person, talk to the other, and go back and forth. It's not ideal, but it's, you know, it is doable. And during this COVID period, I mentioned that I have some clients who don't even want to do Zooms together. So what I've had to do is, you know, do a video conference with one party, and then the other party either by phone or do a separate video conference. You try and find what the comfort levels are, and you try and work around it.
All right, thanks, Franca. Talking about circuit breaker period and courts in general, everything's being delayed, hearings are being adjourned. So are mediations still going to be going ahead through the courts, or are we going to be looking at needing a private mediation more during this time?
Right. I did see a notice, I think it was the SMC, saying they were going to wait till after the circuit breaker to do mediations. But I did see something today about a court mediation that was going to take place by Zoom. So I saw one today. So it's something that, you know, we all need to be updated on whether it's working, whether Zoom is available. But certainly private mediators are continuing to work and using, you know, video conferencing. But I believe I did see today that there was a Zoom mediation being conducted by the court. I think there's some confusion too, because you know, are the courts equipped to handle all the mediations using video conferencing all at once? So there may be a delay because, you know, there isn't enough equipment or enough you know, enough, I don't know, computers or conference rooms to do it. But I think it's still going on, but probably to a lesser degree. And the private mediators like myself, we're still going.
Okay, so how many sessions, if we were going through the courts, how many sessions of mediation would we expect to get or have or be offered, and for how long compared to in a private mediation would these sessions last?
Right. So in court, I've, you know, up to 3 sessions of mediation, but they tend to be shorter. Whereas with the private mediations, they're typically done in a day, but it's a long day. In other words, with the private mediations, you have the first stage, which is the private mediation sessions, and those are done on separate days, privately with the parties. And then you have a full day of mediation, which could be up to 12 hours.
Right.
So I tell the parties ahead of time to get some rest the night before, and to come in very well rested, because it could be a very long day. So generally, to answer that question, there is more time and more flexibility with the private mediations.
Yeah, it would seem so, because I imagine if you have a few shorter sessions that are spaced out, there's a lot of time in between for parties to change their mind or be influenced by other people who want to put their, tuppence worth in. And so, yeah, I can see how that would be.
Yeah, and the courts have a large caseload as well, right? There are a lot of people waiting to get in, so they can't be asked to allocate so much time just to one couple.
And especially at this time now when everything's running behind already. You did mention on lawyers joining in mediations, or should it be, so if you have lawyers, will the lawyers go to the mediation, or will it be only you and your partner that goes to the mediation?
Right. When I do private mediations, I prefer that it's just the parties themselves. Because often when lawyers are present, it becomes a mediation between the lawyers. But I do recognize that parties may need support, and they may have questions, legal questions. So there are various ways of addressing that. Firstly, before the mediation starts, they can go and get legal advice and talk to their lawyers, and that way they can have their position crystallized. And one of the things we help with, and I forgot to mention earlier, is we help you with your position paper. Right. And so when you're doing your position paper, you can go and talk to your lawyer and get all the advice that you want. It's during the mediation that I find having lawyers there to be a bit tricky, for the reason I just mentioned. And then when we have the draft amicable agreement, if parties want to, they can send their draft to their lawyers, and allocate an hour for them to read it and advise their client as whether there are risks or if they should do things differently.
That's one of the questions I was going to ask. Are you able to leave and ask your lawyer on the outside if they're not in there with you, just to check on something as you go along?
Absolutely. You can call your lawyer during the mediation. All you have to do is ask for a timeout, and we'll give you time to call your lawyers. Sometimes people call their friends, but they're not allowed to discuss. They're not supposed to be discussing confidentially, but they may call their friend for a piece of information. Somebody once called a real estate agent because they wanted to know the value of their condo. So all you have to do is ask the mediator for some time out.
Okay. If I've got, I'm currently in court proceedings and they're being delayed, and we've been offered the mediation. Can I take mediation separately from the ongoing court proceedings? Yes,
you can. Absolutely. And then if you've come to an agreement, then to inform the court that you've come to an agreement.
So then you can halt the proceedings and litigation if you come to an agreement.
Absolutely.
And then would that be recorded as an order of court?
Well, once the parties have come to an agreement, then the respective lawyers need to put that into a form of a DCO, a draft consent order, to present to the court. The court could also be informed during a pretrial conference that the parties have reached agreement and we're going to be submitting the agreement. Usually the courts are delighted to know the parties have reached an agreement.
Yeah, so that's if it's a court matter, but what for an amicable separation, just to clarify on this, or a marital agreement, so how is that recorded and how is that enforced? Is it the same way or through a different court?
Well, typically, if in a separation scenario, parties have the option to do an amicable separation or a judicial separation. And most parties won't go for the judicial separation, which means filing the separation in court, because the procedure is as onerous and as comprehensive as getting a divorce. So parties in the scenario of a separation, they typically just want to do a mediation and have an amicable separation agreement, which they will then, comply with voluntarily. So that's not usually filed. If they do want to file it, then it's in the context of a judicial separation.
Okay, thank you. And I just had a question come in, you may have missed, we were talking about it earlier. We don't want the court or any lawyer involved in our financial matters, so can we just use a mediator?
Yes, you can. You can use a mediator who will help you facilitate that part of the dispute. The mediator, though, has to feel some comfort that, you know, both parties understand what they're doing if they haven't consulted lawyers. If one party is bullying, then, you know, the mediator also, you know, would stop the process. But generally, when we do pre-mediation sessions, we know, you know, that gives us mediators, or gives myself an opportunity to know whether the parties really understand all the issues at hand and are capable of going through the mediation. If I also, in the pre-mediation session, see one party's really afraid of the other party because there's bullying, then I also have to address that before we go into the mediation. So basically, I've been known to push back a mediation date because I felt the parties were not ready. There was either too much emotion, or one party was bullying, or one party didn't quite understand what was going on. So I have in the past put the brakes on the actual mediation date and say, we're going to do this a bit later because I think you need some time to digest this and understand this.
Yeah, I had one question as well. I'm being forced, or feel I'm being forced to sign a mediated agreement because my spouse is otherwise threatening to prevent me from seeing the children again. So in this instance, can I sign and contest it afterwards, or I'm going to have to fight?
Yeah, any agreement that's signed under duress, such as, you know, not being able to see your children, or criminal proceedings, or, you know, those agreements can be, you know, held null and void. And so if you're in a situation where you don't want to sign it because you don't agree with it, then don't sign it. You know, call the other party's bluff, say, fine, you know, but I'm not signing something that, you know, that I don't agree with. And if, you know, if they're not letting you see the children, then that has to be addressed, right, with either a custody, care, and control application, or it has to be, you know, or call a mediator and look at addressing that particular problem. But you should never sign something that you don't agree with.
Yeah. Okay. How can agreements that people do come to outside of the divorce process be used in the future? Can they be used in the future to speed up any divorce in the future?
Okay, so, you know, agreements, you know, dividing property, or agreements on children, they won't be upheld unless it's in contemplation of a divorce, unless there's a divorce already in the works. So that's a little bit difficult in Singapore, you know, to uphold. But you know, if the parties have agreed to something beforehand, for example, if they've already divided their assets, then, you know, the assets are already divided. Or if they've come to an agreement on the assets, on how they're going to divide the assets, then the court will look to those agreements as evidence of their intention. So if somebody's showing, look, you know, we had this agreement, even a mediated agreement that showed, you know, I was going to get this much maintenance, the court will refer to those as evidence of an intention. And in that case, they're very useful.
Right. Can I use a mediated agreement signed in one country and enforce it legally through the courts in another country? I think you mentioned something about this. It's a bit complicated area.
Right. Okay. So I did mention earlier that the Convention on Mediation, the Singapore Convention on Mediation, won't help us because it doesn't cover family disputes. But however, you have to look at the contract. Your amicable agreement coming out of the mediation is a contract. And basically what you're doing is you're taking a contract entered into in one country and having it enforced in another country. And our experience has been that the agreements we've done in Singapore with mediation have been enforceable just about everywhere. For them not to be enforceable, a party has to show that, the rules for contract formation weren't followed. For example, a party didn't have the capacity, to enter into that contract, or, it was written in a language that they didn't understand, or there was a huge error. So for the most part, they are enforceable.
Right. Okay, thank you. So here's a question. What does without prejudice mean? And in relation to, if we almost come to an agreement in a mediation, but never get to the actual signing point because one or either party changes their mind, can things that have been discussed in the mediation be used in court matters in the future?
Right. So let me deal with without prejudice. What without prejudice means is that you are able in a mediation to say anything, and it can't be used outside of that mediation room. So you're able to, if you want to make an offer, for example, you offer and say, okay, I'm going to give you $5,000 maintenance a month. But then the mediation, there's no agreement signed, then that offer doesn't stand anymore.
Right.
So you're able, so that's what the without prejudice, it means without prejudice to your rights.
Right.
So you can say anything. Now, if you agree to something, but then you don't sign an agreement again, then there's not much force that that agreement can carry, because you've said it without prejudice, but then in the end you didn't agree. It's not in an amicable agreement or in any other agreement. Therefore, it's not an agreement.
Right. Okay. Thank you for clearing that up. And I guess lastly, fees, fee structure, and how does that work? Do you do only full day mediations, or for smaller matters, could it be a half day? And how do you, I guess every case would be different, or do you have a general?
Yeah, we do have a package that's very attractive, and I can share it with people on an individual basis. So we have a package that does include the pre-mediation session. It includes helping you with your position paper, the agenda, full day of mediation, and the contract or the amicable agreement at the end. We do have a full package, but then we also have, mini mediations, as I call them. Where people come to us and say, look, we've agreed to everything except this, except, childcare, custody and control, and or child custody, care and control, or we haven't agreed on the division of assets. And then we can do a mini mediation that's half a day or a couple of hours long, where we just hone in on that one issue. And for some of the mediations, I won't do a whole pre-mediation session if it's just focused on one issue. I'll talk to the parties. I will always try and meet the parties beforehand, even if it's just for half an hour, to explain the mediation session. But when you have those one-off issues, you don't need to do, full-blown pre-mediation sessions. You don't need to, spend a lot of time in the pre-mediation stage. You can often just get right into the issue. So yes, the answer is yes. We have different types of mediations: full day, half day, a couple of hours, and we're able to do them by video conference. Less desirable by phone during this COVID period. With parties in different rooms. At the end of the day, it's the parties' mediation, and we try to figure out what works best for the parties, how much they can afford, what they really need, how it's best to do it, and then we cater it to them.
Thank you, Franca. That's very helpful. One last question just popped up. I think we're probably almost out of time now. Again, going back to without prejudice, if you get an offer and you don't agree with it and it escalates to court, you might lose everything.
Yeah, it's a gamble you take, right? With any offer. If somebody makes you an offer in a mediation and you say no, then there is no agreement. And then when you go to court, you're back to square one. It's as though that offer never existed. That's what without prejudice means. And
when you get to court, you never know whether, you're going to do better or worse.
Exactly, exactly. And that's the same for negotiation as well, right? It's not just mediation, it's anytime you get an offer, you know, you sometimes think, well, am I going to do better in court? But when you do get to court, you're back to, you know, you're back to the beginning, and the offer may not be as high as what it was before going to court, or may not be as high as what it was during mediation, because often people factor in the cost of lawyers. Oh, now we're in court, and whereas before I was going to offer you $100,000. Well, now I've just spent $20,000 on my lawyer, so I'm only going to give you $80,000. So, you know, sometimes accepting an offer in mediation is a good idea because of the risk.
Yeah.
You don't know what's going to happen later on.
Okay. Thank you, Franca.
Sure.
Another question, but it's more on maintenance. So I think perhaps we can address it privately.
Okay, if it is, sure. And again, for all of you listening in on this, please email us, you know, email myself or Catherine, schedule a free phone call, and you know, we're happy to help you on a one-on-one basis.
Okay, thank you, Franca.
Thank you very much. Thank you, Catherine. Thank you, Margaret. And thank you, ladies and gentlemen, for taking up your time and listening in. Thank you, and have a great rest of the afternoon.